Welcome to The Docket. I'm your host, Corey Snow. In this episode, we're going to hear the consent bond order and release conditions for Donald Trump in the Fulton County, Georgia criminal trial for Trump's alleged attempts to overturn the 2020 Georgia election results. This bond order sets the amount of money Trump must post to be released, as well as sets specific conditions for his behavior that he must adhere to as a condition of release. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the Superior Court of Fulton County, State of Georgia, State of Georgia v. Donald John Trump, Case number 23SC188947, Judge Scott McAfee. Consent bond order for defendant Donald John Trump. The above-captioned matter having come before the court for consideration of bond, and with consent of counsel for the State of Georgia and for the defendant, the court hereby grants and orders that bond is set in this matter as follows. 1. Bond amount. Count 1, violation of Georgia RICO Act, $80,000. Count 5, criminal solicitation, $10,000. Count 9, criminal conspiracy, $10,000. Count 11, criminal conspiracy, $10,000. Count 13, criminal conspiracy, $10,000. Count 15, criminal conspiracy, $10,000. Count 17, criminal conspiracy, $10,000. Count 19, criminal conspiracy, $10,000. Count 27, filing false documents, $10,000. Count 28, criminal solicitation, $10,000. Count 29, false statements, $10,000. Count 38, criminal solicitation, $10,000. Count 39, false statements, $10,000. Total, $200,000. Defendant may post bond as cash through commercial surety or through the Fulton County Jail 10% program. 2. The defendant shall not violate the laws of this state, the laws of any other state, the laws of the United States of America, or any other local laws. Ayala v. State, 262 Georgia 704-705, 1993. 3. The defendant shall appear in court as directed by the court. Ibid. 4. The defendant shall perform no act to intimidate any person known to him or her to be a co-defendant or witness in this case, or to otherwise obstruct the administration of justice. Ibid. This shall include, but is not limited to, the following. A. The defendant shall make no direct or indirect threat of any nature against any co-defendant. B. The defendant shall make no direct or indirect threat of any nature against any witness, including, but not limited to, the individuals designated in the indictment as an unindicted co-conspirators individual 1 through individual 30. C. The defendant shall make no direct or indirect threat of any nature against any victim. D. The defendant shall make no direct or indirect threat of any nature against the community or to any property in the community. E. The above shall include, but are not limited to, posts on social media or reposts of posts made by another individual on social media. 5. The defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him to be a co-defendant in this case, except through his or her counsel. 6. The defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him to be a witness in this case, except through his or her counsel. It is so ordered this the 21st day of August, 2023. Signed, Honorable Scott McAfee, Judge, Fulton County Superior Court. Consented to by, signed, Fonnie T. Willis, District Attorney, Fulton County District Attorney's Office, Counsel for the State of Georgia. Signed, Drew Fendling, counsel for defendant. Signed, Marissa Goldberg, counsel for defendant. Signed, Jennifer Little, counsel for defendant. This concludes this episode of The Docket. I hope you enjoyed this narration of the bond order and release conditions for Donald Trump in the Fulton County, Georgia criminal trial. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/DocketPod. Thank you.